Hey everyone! Welcome back to today's video. We've got 3 sovereign citizens appearing in court today, starting with an update on someone we've covered before, Michael Stanley. Let's get into it.
Okay, we're on the record now for 25 CR 745, People versus Michael Stanley. Mr. Stanley, I see you on WebEx. Can you hear me? Hold on, we have to unmute you.
Sorry, yes.
All right. So we're here. You would wanted to enter a not guilty plea and set for trial. However, I did state you have to be in person to do that, and you have to be in person anyway, but that you have to be in person, especially if you have any other warrants, and I saw that you still do. What is going on? Where are you?
Okay. I do want to let the court know that I did relocate to Laramie from Pinedale to be closer to Colorado. And I'm in a rental assistance office right now. And I'm sorry, it just so happened to land at the same time. So I'm trying to juggle both things at the same time. Yeah, that's where I'm at. And I apologize for not being able to be there in person. I just don't have the funds to make it now. And that's why I'm here, because I took on $1,200 rental agreement. And I'm trying to make sure that I don't lose it. And in regards, I don't know, I know that the lower court had a 25th meeting, and I'm not sure if there was a warrant put out or what is going on. Since I did change addresses, I have had no correspondence since I left Pinedale. I did do a change of address though.
Did you file that in the case?
No, sir. I'm sorry. I did that at the post office. This has just happened recently. I've only been here a few weeks.
People?
Well, Judge, he has a warrant out of F25M603. They're based on a failure to appear. It looks like he has been appeared by WebEx back in December, was told he needed to be there. There was a show cause hearing on March 25th that he failed to appear at also, so his bond judgment entered on
Yeah,
that
this has
bond.
been an ongoing thing.
Mr. Stanley, hold on, I'm not done. So there is no open.
I'm sorry, it's going in and out.
There's no next court date in the misdemeanor case because of the failure to appear. At this point, Judge, given the number of times we have been doing this where he's been trying to appear by WebEx, it frankly looks like he's just trying to avoid dealing with that misdemeanor warrant. So my request is that the court find that there's been a failure to appear given the number of times he's been told to appear in person, and to issue a warrant in this case for his arrest.
I object to that because I don't think that's appropriate. The only reason I'm not showing up down there, and I did show up down there once before only to get arrested, is I'm not trying to lose my place to stay and sit here and keep trying to bail myself out when I'm not willfully violating conditions of my bond. If this would be simply consolidated and handled in the district court, as I've been putting you guys on notice about this, it wouldn't be a problem. I'd be there every time. I can't, you guys want me to come there week after week. It's not economically viable. I used to live 6-7 hours away. You guys want me to come on the 25th, the 2nd, the 7th? I mean, this has been an ongoing thing. So you cannot create like undue hardships and go against my constitutional right to travel, which he gave me permission to do, by the way, and then have a lower court fighting the upper court. This makes no sense. I'm not the one doing this. Let's put that in perspective really quick.
Of course, you decided that your so-called right to travel includes driving a motor vehicle without the proper license, and somehow that's everyone else's problem. Honestly, that sounds a lot more like a you problem than anyone else's.
Judge, he's the one not showing up to court. So my request
I'll
on
be
this
there. I'll be
one
there tomorrow.
is that
I'll be there tomorrow.
the court issue
I'll be
a
there
warrant
tomorrow.
on this
I'll be
case.
there
He's
tomorrow.
been
Hold on.
told multiple times to appear in person. He has not. So my request is for a warrant on this case.
It has nothing to do with this court. That's not why I'm not appearing.
That's enough. So what we had is I issued an order. I issued an order in this case that we didn't issue a warrant for him last time he appeared on WebEx. And the order I issued indicated, because he wanted to set this matter for trial, that he was reminded to appear in person to enter a plea and cannot appear remotely if there's an outstanding warrant and he indicated he was going to get that worked out. It's not worked out. And so we have a situation now where I put that out, that went out March 5th. That was almost a month ago and it was approving WebEx virtually for that last hearing, which was done, but with the reminder that any plea or if there is a warrant requires in person. It's not my warrant, but it's a warrant, and that is clearly spelled out in this now month-old order. So I don't think it's a matter of no advance notice. The court finds that it's appropriate, the people's request is granted, and we'll set this matter when there is a cancellation of that warrant.
Well, if I filed that habeas, I don't know the proper procedure to try to get this thing quashed or otherwise move forward without continuously having to get arrested.
Happy to look at any motions that may come in. I'm happy to look at them, but the order was clear.
Well,
The order was issued.
It was my understanding that I had to get it alleviated through the party or otherwise the judge in question, which is it's this constant battle between me and him. I don't know what. And now that I've asked,
I don't get to set his warrants.
I don't get to. You got to remember, I've got.
Sir, I don't get to set his warrants. I told you that last time.
Yeah.
But what I am here for is I had an order saying that you need to be here in person if you had a warrant or if you wanted to set this for hearing, for trial. Whether you set it for trial doesn't matter because you have a warrant, which means you need to be here. So that's a rule that's building wide. That's not just a me or a him thing. That's if you have a warrant, you're not allowed to appear virtually. I made that very clear on March 5th, and that's the way we have to stick with it. I'm not the one who chose to schedule something at the same time. So we're going to go ahead and give the people what they asked for, and we'll be in recess.
So what does that mean now?
That means you essentially, for purposes of this order that put you on notice, you failed to appear. And you will now.
In your court now.
Yep, and you will now have 2 warrants.
Wonderful.
All right, we're in recess.
So you guys are going to make me homeless. Is what you're trying to do. Okay, that's cool. I appreciate it.
Maybe you would have appreciated that more if you had taken care of your warrant like you said you would the last time you appeared. I covered those earlier hearings, and they made it very clear you needed to show up in person for your next court date, which you didn't. Instead of dodging your responsibilities, you should have turned yourself in and handled the issue properly. Then you wouldn't be sitting in the same situation all over again, just in a different courtroom. All right, let's move on to the next one.
I'm sorry, sir, who are you?
My name is Justin Anthony of the House of Kaminsky.
I see. Thank you, Mr. Kaminsky.
I apologize. My clippers died halfway through a haircut. I could put my hat on if it pleases the court.
It's okay. Thank you. I'm just happy that you appeared. Court will recall 26 CR6. People v. Dustin Kaminsky. He was on a PR bond and appears. This case will be set for filing of charges. Were charges filed? Thank you. Did you have you received the charges? Nope. Okay, give us just.
I don't think charges were filed on this one.
Okay.
Whoever made the case didn't find those. It looks filed online.
Oh, okay. So there will be some filing of charges. That will be next Tuesday, March 24th. So you'll have to come back here March 24th at 1:30 here at the jail, okay?
Okay.
And then the district attorney's office will, because at this point you are accused of a crime, you were arrested, but then the district attorney's office has to file the official charges against you.
Okay.
And so you'll need to return back here March 24th at 1:30, and you'll remain on bond, and unless you fail to appear, then that bond could be revoked. So that's the paperwork, and you'll need to come back for the filing of charges. And then if you are looking to have the public defender's office represent you, you'll have to apply for their services, okay?
Okay, so since the files haven't been, or charges haven't been filed yet, I can't inquire against what the nature and cause of the case against me is?
Well, you were arrested on January 2nd, of 2026, and so that's what the charges arose out of.
Okay, is this a criminal court or is this a civil matter?
This is a criminal matter.
Okay, I'm here by special appearance. I'd like to challenge, subject matter jurisdiction and personal jurisdiction.
Yeah, this isn't the time to do that.
Okay,
but
that's
we-
why I asked
but-
about, this filing the charges yet.
Yes, and so we will address that, but not at this time.
Okay, and that was the 26th at what time?
No, it's the 24th, March 24th at 1:30.
Okay,
Yep.
Take
and
your
the
time,
piece-
thank you.
And the piece of paper that you have has that date on it. Do you see it?
Uh,
Why
This
don't
could
you?
help.
Yeah, go ahead. Why don't you put your glasses on and why don't you repeat that date to me?
yes, March 24th at 1:30 p.m.
Okay, thank you. We'll see you back here at that date and time.
Have a good afternoon.
Thank you. You too.
All right, that was a short hearing. To his credit, he did show up for his last court date on the 24th of last month, where the charges were eventually dropped. However, he was on probation and failed to appear at his revocation hearing, which led to him being arrested again, along with the rest of the House of Kaminsky.
It's 23 CR 5243, People versus Dustin Kaminsky. Can you hear me, Mr. Kaminsky?
I'm also hard of hearing, but I can hear you, sir.
Okay. All right. Can I have entries?
I'm Dustin Anthony of the House of Kaminsky. I'm here by special appearance to challenge both personal and subject matter jurisdiction.
It looks like you're represented by the public defender. Is that right?
He was at one time, Your Honor. If he wants counsel to be appointed, we can enter today. This would be my first time actually appearing with him if he wants a public defender.
So, Mr. Kaminsky, because you're in custody, you have a right to a public defender if you want one. Would you like me to
Okay.
appoint the public defender?
I can speak for myself, Your Honor, but any help would be also acceptable.
Okay.
I guess then that sounds like a yes. So I will go ahead. And are you Ms. Barton?
I'm Camille Taylor,
Oh, okay.
bar number 48054.
Okay, thank you. And for the people?
Lindsay Maas for the people, Your Honor, attorney registration number 49996.
Okay. And would then this be your case, Ms. Taylor?
It would be, Your Honor.
All right, I will appoint Ms. Taylor on this case. Looks like, is this a first appearance on an arrest warrant?
This is a revocation of probation matter. It looks like we need to set bond. It was previously set at $450 cash back in 2024. So, but since he's been arrested this time, we don't have a bond set.
Okay, would you like to be heard on bond?
Yes, please. Given that the prior bond was a cash bond in the amount of 450, I would ask for a slight increase to 475 cash.
Okay.
I would
Anything
ask for a PR bond, Your Honor. I don't have any cash on me.
Okay, well,
Alternatively, a PR.
so, Mr. Kaminsky, here's the thing. If you have the public defender representing you, they speak for you, okay?
Well, then I
So-
can speak for myself, Your Honor.
There's a verified complaint from the probation department stating that you failed to appear for your revocation hearing and that you also picked up new charges. Even though those charges were later dismissed, probation usually includes a condition that you won't engage in criminal behavior. Violating that condition is a breach of the agreement you signed when you accepted probation in the first place.
Okay, well, let's hear from the people.
Thank you, Your Honor. The people are recommending a $600 cash-only bond. We'd note for the court that Mr. Kaminsky was initially on a probation revocation summons. He showed up for his first court date several hours late, avoiding a warrant at that point. He failed to appear at his next appearance, and it would seem that while on failure to appear status, Mr. Kaminsky has picked up an additional felony case in Boulder County. We do believe that the increased cash bond value is appropriate based on the failure to appear as well as the other records made by the people. Thank you, Your Honor.
Your Honor, that felony case out of Boulder County was dismissed, and they also entered a motion to quash the arrest record, and it was signed by the judge in Boulder County.
Okay, well,
So
if,
there
Mr.
is no felony case out of Boulder County at this time, sir.
All right. Even assuming that that is true, I'm going to find, based on the failures to appear in the history of this case, that a cash bond is appropriate. I'm going to set bond at $500 cash only, with all original terms and conditions.
And Your Honor, how can this be a court of record, a criminal case, if there is no verified complaint by a living injured party?
That wraps up the second defendant. He's got another hearing coming up in a few days, so I'll have an update later this week if anything develops. Now, let's move on to the final hearing of the day, which features an in-custody sovereign citizen who's already well known to the judge overseeing the case.
Okay, there's been a complaint filed by the probation department. I find that that's appropriate, and that this is a court of record for that purpose.
And then, Mr. Kaminsky, you have the right to a revocation hearing within 14 days of today if you want to set immediately. That would be an evidentiary hearing where the prosecutor would have the burden to prove that it's more likely than not that you didn't comply with your probation. So you could set that today immediately, and the judge would have a 14-day timeline in which to hold that hearing. Otherwise, you could waive the 14 days and set that hearing literally any time, whether you're in custody or out. I would rather meet with you to discuss the allegations before we set a hearing, which would require you to waive the 14 days. Are you okay with taking that approach?
I don't have the $500 cash on hand, so I'd rather just take care of this right now.
We can't, either way, we're not taking care of this today just because I haven't talked to the DA about a plea offer, and I don't even have a copy of the complaint against you.
Okay, I completed treatment, I completed
But Mr.
the
Kaminsky,
class that was
Mr.
required.
Mr. Kaminsky, don't talk about the facts. So I'm going to chat with him if that's okay, counsel.
That's fine.
So, Mr. Kaminsky, as your attorney told you, you have a right to a hearing on the complaint. Because you're in custody, you have a right to that hearing within 14 days. If that's what you want, we will set a hearing for you. Your attorney would like some time to talk to you and see if she can reach an agreement with the DA. That may take more than 14 days, and that's how this is typically handled. If you want her to try to do that, you would have to waive your right to a hearing within 14 days. We'd set a status conference at a time that the attorneys agree to, and if you're not able to reach an agreement then, we would set a hearing. So do you want
Well, I
me
don't
to
see
say-
why my attorney couldn't handle this within 14 days and review the evidence and also review with the district attorney. I'm going to be sitting here since I don't have
Okay.
bond. Would the court
All right.
consider a PR bond?
No, I wouldn't.
I would be able to prepare better
Mr.
for this case.
Kaminsky, you need to let me talk now. I'm going to find that he's not willing to waive his right to a hearing within 14 days. We will set a hearing. If the attorneys are able to work something out prior to that hearing, that's great. But if not, we'll give you your hearing within 14 days, okay? Can we get a date?
How long do you need?
Can we please have an hour, 45 minutes?
I can do August 8th at 2.
August?
Or, I'm sorry, April 8th at 2.
Does that work for counsel?
April 8th at 2. That'll be fine.
We can accept that, Your Honor.
All right, so Mr. Kaminsky, your hearing is going to be April 8th. That's a week from now, more or less, at 2 o'clock. Your attorney will, I'm sure, try to be in touch with you before that to talk to you about your options and to prepare for a hearing if there's going to be a hearing. Okay?
Okay.
All right, thank you.
Have a good morning.
You too.
Mr. LeBeau?
Yes, Your Honor.
Mr. LeBeau, good afternoon again.
Good afternoon. How's it going?
It's going well, thank you. I wasn't hoping to see you so soon again. I gotta tell you.
Things happen.
I know it happens, I know. I just was hoping for a time where you and I, not that I mind seeing you, I just wanted you to have some space, you know what I mean? So the case is 26 CR 388, comes on for an advisement. The court does find probable cause. Regarding the bonds, Mr. LeBeau, let me hear from the attorneys. Ms. Cunningham?
Judge, we will be requesting a personal recognizance bond with the appropriate conditions. That is what is recommended in the bond application. So we think that is appropriate here, and also given the nature of the charges, it appears to be a lower level felony if I had to guess.
You don't have to guess. DA, bond.
Your Honor, I am asking for a $5,000 cash or surety bond. I recognize that this isn't, a super aggravated felony case, but I'm definitely concerned about his ability to comply in the community and to return to court. It looks like he has 8 failures to appear in the last 4 years. most recently being 2 weeks ago in the case that he's currently on probation for. So those are my concerns, and I think a secured bond's appropriate.
Your Honor, may I have word?
If you want one, I can tell you this, your attorney probably doesn't want you to speak, but I promise you, I'm not going to stop you if you want to talk briefly.
Well, just directed towards the district attorney. I'm part of the Oklahoma Sioux Tribe, which with Medicine and Wheel Coalition is a coalition with the People's Republic in Boulder County.
Mr.
I know, we've talked about that. You and I have talked about that in my courtroom. I know that.
If they haven't contacted President Starkham's or President Dolan Wood and I, why wouldn't I be released back in the community? Because they, honestly, I'm immune. I'm sovereign. I'm a sovereign citizen.
I got you.
So I don't even know why. I already have hostage and ransom insurance on this claim right now.
I got you.
The incident that happened, I own Wells Fargo. My grandpa's the owner of Wells Fargo.
I got you, Mr. LeBeau, and I've heard some of those things, not all of those, but some of those before. And while I do want you to speak, if you want to speak, I got to tell you straight up, it's not helping the case right now. It's not a useful thing right now. You know what I mean? I'm going to set bond as follows: $5,000 cash or surety. Conditions: no contact with alleged victim. Pretrial supervision via CJS. Report to your Boulder County probation officer within 24 hours of bonding out. No drugs, no weapons. Stay away from 1801 13th Street, Boulder. Filing of charges Friday, April 3, 1:30 p.m. Right back here. We'll see what charges the DA chooses to file, if any, in the case. Thank you, Mr. LeBeau. We'll see you in 2 days.
You're the victim of your own poor judgment and gullibility. And even if what you're claiming were true, which it isn't, and your family actually owned Wells Fargo, then coming up with $500 for your release shouldn't be an issue. That he did have a hearing this past Friday, but unsurprisingly, he didn't show up and no real explanation was given. It's possible he bonded out and was simply assigned a new court date. That I'll be keeping an eye on the self-proclaimed window licker. And if there are any updates on his case, or any others I've covered, I'll make sure to keep you posted. If you liked the video, hit the like button. If you didn't, hit dislike. But don't forget to drop a comment and subscribe with notifications so you don't miss any future content.